everyone, and welcome to this webinar, which we have finally called an introduction to housing rights in Portugal. We are going to look at possible ways to advance housing rights of the homeless people, and we're going to do a short introduction to housing rights in Portugal. Hopefully in the future we will be able to do something more in depth. But right now, let's call it introduction. So let me first of all introduce myself. My name is Maria Aldanas. I'm policy officer at FEANTSA, and I coordinate something which is called the Housing Rights Watch. For those who don't know, FEANTSA is a European federation of organizations working with the homeless. We are based in Brussels, and what we do here in Brussels is try for all the topics about homelessness that make sure that they are in the agenda of the institutions, the Commission, the European Parliament, etc. And the Housing Rights Watch is a project of FEANTSA in collaboration with Fondation Abbé Pierre. It's a French foundation. Our aim is to disseminate everything to do with the human right to housing, or housing as a human right, as you prefer. So what we do is we support and engage in advocacy and litigation on housing rights. This is mainly what we do. And just to say that this short introduction training, it was meant for FEANTSA Portuguese members, but that we have opened it to a larger network. So we agreed with Ricardo from AMI and with Ana Martins. By the way, thank you to Ricardo and Ana Martins for their help to organize this event. And well, I hope that the limitations of the online format will not reduce the quality of the event. I think we're all a bit, let's say, tired of the webinar. And so all the speakers have a PowerPoint presentations to allow to better follow the presentations. So we will be able to share it with you throughout the conversation, okay? And just a reminder that all the materials will be on our website. So the program, our description, and the different presentations will be online in our website. Okay, so once I've said that, I would like to share with you my presentation, as I said. I hope. Okay. Sure. Okay. Can you see it? Just let me know if you can't, because sometimes it can be difficult to follow if you cannot see it. Anyway, from now on, I can only see my presentation. So if I think Alice is supporting me. Alice from the office is supporting me. If you see something or hear something that I cannot see, stop me or say something, okay? Because this format is a bit complicated sometimes. So, okay, wonderful. Okay, so introduction to housing rights in Portugal. So, first of all, oh my God, it doesn't work now. Okay. What I'm going to talk about is about the human rights-based approach to homelessness. So it's a different perspective to what we are normally used to here, because it's not about social services or health services, but it's about the rights of the homeless. So I'll speak a bit about our vision, the different approaches to homelessness, how that has evolved from the charity approach or the needs approach to a more human rights, housing rights-based approach. And then I will speak a bit about the advocacy role of the organizations and the use of advocacy and litigation to defend the rights of homeless people. And I will end my presentation speaking about some of the legal instruments that exist at European and international level to defend human rights, but to defend as well the human right to housing. So in FEANTSA and Housing Rights Watch, we believe strongly that homelessness is a situation that deprives individuals of human rights, including the right to housing. So that's why at some point in the early 90s, among the different working groups that we had a group, an expert group on housing rights expert group. That was the beginning of something that we are doing right now, which is Housing Rights Watch Network. And what we do there is mainly about the right to housing, disseminating the right to housing, monitoring everything to do with case law, so jurisprudence that and all the progress that there is in terms of jurisprudence about the right to housing and other connected rights. We support strategic litigation. You may have heard that FEANTSA was engaged in litigation through collective complaint mechanisms. So I will tell you a bit more about that later on. We have developed links with human rights organizations. So obviously there are many actors that are working at European level on these social rights and human rights and housing rights specifically. And lastly, there's something that we also do is to try to raise awareness about and fight criminalization. And I'm going to try to be as quick as possible and try to stick to, because we said I will finish more or less about 10:30 Portuguese time. So I have more or less 20 minutes. Let's see if I can keep it. Anyway, so the first thing I would like to say is when you talk about the right to housing and when you talk about housing rights, are we talking about the same thing? Well, not exactly. Okay, so for me, the right to housing refers to a human right codified in international treaties, in constitutions. For example, I know the Portuguese constitution mentions the right to housing somehow and in other texts. So a human right is the recognition of the human dignity. So accessing housing is connected directly with the human dignity. And housing rights are more about how legal rights are codified in national domestic law, such as, for example, everything to do with social housing, for instance, or for housing benefits, or, okay, so that will be like the concrete development of the right to housing in domestic law. I hope that was clear, because this is like the basis of everything. And one of the things that I wanted to mention today, it's this the shift that has been happening over the years. So FEANTSA members have for many years been specifically service providers that would give assistance to the homeless because people needed assistance. And I guess the charity approach and the needs approach was the traditional approach to homelessness. So we try to go a bit beyond those approaches and try to focus more on the individual and the groups, so the homeless people, to be empowered to claim their rights, either directly by themselves, participating in a certain way, or indirectly through organizations that defend their rights. But the basic is that individuals are entitled to assistance, and that we should focus more on the structural causes and their appearances. So when I mean structural causes, meaning more about housing, for example, so the structural causes of homelessness, so the lack of housing. And of course, what we have been trying to do from at FEANTSA and Housing Rights Watch is try to defend the rights of the homeless, but even the basic rights, like for those people that don't even have a roof or a home. So I'm thinking mainly of people that are sleeping rough, or even in shelters or in reception services, diverse services. to remind ourselves that homeless people have the same rights as citizens. So it's about equality and non-discrimination. Trying to bear in mind that even though these people have many difficulties in life, we should still be able to respect their most basic human rights. So, of course, criminalization in this sense has been an issue of concern, especially at local level with local regulations, establishing measures that will swipe away homeless people from the city centers, from the public spaces, and obviously measures that are not always targeted at homeless people, but they may affect them disproportionately. For example, the prohibition to eat or drink in public spaces, for example. And also that we are quite aware that sanctioning or repressing or arresting homeless people does not solve the problem. So there's a lot of research on this. On one hand, homeless people cannot pay fines when there are fines. And for example, in the States, it's been proved that a police perspective is not only costly, but also highly inefficient. So what's the alternative? The alternative focus is finding ways out of homelessness based on the rights of homeless people. And that's why we did this Homeless Bill of Rights campaign. You might have heard about it. It's a few years old. So it was a campaign addressed to the municipalities mainly. There are a few, I think there are at least 60 to 70 municipalities that around Europe that have already endorsed the Homeless Bill of Rights. Here you have a list of all the rights that it includes: the right to housing, the right to emergency accommodation, the right to postal address, the right to use public spaces, the right to equal treatment, the right to sanitary facilities, right to emergency services, the right to vote, the right to data protection, the right to privacy, and the right to carry out survival practices such as begging, for example. So I will try, when I finish my presentation, to copy a few links about some of the things that I have included in my presentation so that you can go to the website to look for more information. Okay, but you can already Google FEANTSA Homeless Bill of Rights and you will find the information very rapidly. Anyway, so having said that, I wanted to remind you of the advocacy role of service organizations. I know that in FEANTSA, there are many organizations that are service providers, but there are others that, because of they're bigger or because they have decided to do so, they have begun an advocacy role. So advocacy meaning that you as an organization, as an individual or group, aims to influence the decisions and also the laws within political, economic, and social systems. So examples of advocacy, I mean, I'm not going to give you a dissertation on advocacy. This is not the purpose of this introduction, but people are doing media campaigns, commissioning public research, making amendments to laws, to advocate to include the rights of the homeless in laws, for example. And then obviously the advocacy on housing rights is speaking up for homeless people, acting on their behalf and defending the right to be housed, and all these other related rights that we mentioned. And of course, part of the human rights-based approach to the right to housing is the participation of homeless people. So approaches must be from the bottom to up, not the contrary, not the opposite. So apart from the advocacy, which is something that organizations can do, FEANTSA does advocacy mainly at the EU level, but also helps our own organizations to do advocacy at local level. We do strategic litigation. So why is this important? Because so what it is, first of all, what it is, it's a legal action used to single out, so to choose cases that we will bring to court or to some committees or quasi-judicial bodies, what I see written in the presentation, to achieve a specific goal. So the idea is that when we take this case to a court or to a judicial body or non-judicial body, we try to achieve a broader impact on law or on policy, and set a precedent for outcomes in similar cases in the future. And that's, for example, what we do when we do collective complaints in FEANTSA. Okay, so even when the right to housing is not always explicitly recognized but derived from other rights, we use also all that case law, jurisprudence that comes out of the strategic litigation to define minimum standards related to the right to housing. So, for example, in terms of homelessness, let's say that a person should not be evicted without an alternative accommodation, for example. That would be like a minimum standard. So what are the legal instruments that we have available at European and international level? So first of all, we have the UN system, so at the international level. You may have heard of the International Covenant on Economic, Social, and Cultural Rights. So here, for example, the main article is Article 11, which is about the right of everyone to an adequate standard of living for himself and his family. And this adequate standard of living includes adequate food, clothing, and housing. Of course, this is probably an ideal. We are working towards the progressive realization of this right. It's still not true in many societies, not only in Europe, but the idea is that these social rights at international level should be slowly, continuously make improvement on the living conditions of the society. So at international level, you have this Committee on Economic, Social, and Cultural Rights, which is a body that interprets the content of this right to adequate housing. So, for example, this committee has analyzed in a general comment number 4, it is called the elements of the right to housing. So when we are speaking about the right to housing, we're speaking about what? We're speaking about legal security of tenure. Okay, so whether you are in rental accommodation or you're a homeowner, or you're in a cooperative housing or emergency housing, to have some kind of security of tenure. Okay. Also, availability of services. That's to say that if you have some accommodation, but you don't have facilities for health, security, comfort, and nutrition, that also it's part of the right to housing. But I think probably the elements in which we have been focusing in the last years, because they're the more difficult ones, is affordability and habitability. So the affordability means that a person or a family must be able to afford the housing, so that they can, when they pay their housing, they still can pay for other basic needs. And these basic needs are not compromised by paying their own housing. So affordability is one of the big issues in Europe. You've probably read the latest reports of FEANTSA, Fondation Abbé Pierre, and how the income, well, the rent levels have increased a lot, for example, and the income of the families have not increased that much. So that difference. Also, habitability. Obviously, the housing must be adequate and protect you from cold, damp, heat, rain. So unfortunately, unfit housing is still a problem in Europe, in many European countries, and I guess Portugal as well. There's also accessibility, location, and cultural adequacy. But I'm not going to dedicate too much more time to this. Otherwise, I won't be able to tell you, to finish the presentation or what I would like to share with you today. So yeah, about the international covenant that I mentioned. So this will be the, let me see if I can use the pointer. Okay, so you have the international covenant, which is the international treaty where the article it's included. You have the committee that interprets Article 11 that I already mentioned. And what they also do, this committee, so it monitors compliance of the different states of the international covenant. So meaning that every every state internationally has to provide the committee with a report on how they're doing on economic, social, and cultural rights, and that includes what is their progress on the right to housing. So in terms of Portugal, okay, I didn't speak about this. The optional protocol allows to introduce individual complaints for the violation of a particular economic, social, and cultural right to the committee. This is what I wanted to say now. Portugal, excuse me, was one of the first states to sign and ratify the optional protocol to be able to present a complaint in case of violation of rights, okay, to the committee. Another possibility that is there, it's NGOs. So the state parties submit to the committee country reports on what's their what they do in terms of social and economic rights, and NGOs can submit what they call shadow reports. I don't know if you have in Portugal that, but maybe some of you can tell me later. But for example, in Spain and in France, there's been platforms of different organizations that have formed to actually send reports, which are also comments on the state party country reports. So this is a possibility to include your advocacy as an organization in this international system. And it can help also introduce advocacy in your own national context. For example, in Spain, they're doing this very well. So I've spoken about the international level. Now I want to speak more about European level. I don't know if you know the Council of Europe, but the Council of Europe has two main conventions, the European Convention on Human Rights and the European Social Charter. And it has the European Convention, it's controlled by the European Court of Human Rights, and the European Social Charter has a European Committee of Social Rights. So for us, for FEANTSA, Article 31 of the European Social Charter is very important because it included for the first time the right to housing, and it included the right to housing and the prevention of homelessness until even the eradication of homelessness is included in Article 31. So it has been a very important step in our advocacy and litigation efforts. And there's the collective complaint mechanism that we have used in the past against France, against the Netherlands, and against Slovenia. We are now in the middle of a collective complaint against Czech Republic, also in relation to the right to housing. And of course, in the area of the European Union, which is, we have to make the difference between the Council of Europe and the European Union. So the Council of Union, it's made up of 47 countries, which is completely different from the European Union. But all of the European Union member states are part of the Council of Europe. Okay, this is not simple. I don't want to talk too much about it, but I always, show this graphic to show the huge difference between what the Council of Europe does and the European Union. Okay, so here we are, the European Union, with the European institutions, the different treaties. The Charter of Fundamental Rights has Article 34. Okay. Anyway, this is quite complex for someone. I don't think any of you is a lawyer, so I don't want to insist too much on that. So Portugal again has signed and ratified the European Social Charter. So the European Committee also monitors compliance with of the different states with the European Social Charter, and there's also an additional protocol that allow groups, allow FEANTSA, for example, because we have our status before the Council of Europe, to lodge collective complaints. And also there's the possibility for the NGOs to send comments to the different reports of the different states. I am trying to do this as graphically as possible to simplify things, but if you have questions after my presentation, please don't hesitate to ask. And for example, this is what I was telling you about. When we go to these European courts or European bodies, there are different decisions, resolutions, rulings that create binding obligations for the states. And they create binding obligations because these member states, including Portugal, have signed and ratified all these international and European conventions. So for example, about homelessness, this says in terms of prevention, the European Court of Human Rights in several cases, but in Jordanova and others is like the most clear, that no eviction must take place if the public authority has not looked for alternative housing, for example. I'm just giving this as an example, okay? And I think this is the end. I have tried to be as clear as possible, and it may be a bit complex for you to understand, but now you have your turn to maybe ask questions, and I'll try to solve them if I can. Any questions? Okay, maybe you can put your questions in the chat already, or maybe someone from the speakers. No?
Maria, maybe I could ask a question if you allow me.
Yes,
I was checking this last board that you put on the PowerPoint, and it's very impressive. What do you think has been the current analysis of the proportionality principle in what regards, for instance, evictions, generally in an international, as you said, both Council of Europe, International Covenant, even not as much the EU because there's no direct competencies on housing, but nonetheless, what has been your general appraisal of proportionality, margin of appreciation from these entities?
Well, this really goes beyond let's say the content. Dulce was referring to this So the idea is, let's explain for the people that are here that don't have a legal background, that the principle of proportionality means that the court has to put in the balance the right to housing and the other rights, like in normally it would be like the property rights. So for example, and we have dedicated a whole workshop to this, Dulce, so it's quite a complex matter. But let's say that everyone that has their home taken away from them needs to be at least that a judge takes a look at the consequences of that eviction, so that if the person is going to become homeless because of this eviction, so the judge needs to put into the balance the different the consequences of the action and the different interests in the so this is the principle of proportionality. And of course it's not the same thing it is if it is when people are squatting in an informal settlement, for example, in a land that belongs to the municipality, or if people are obviously in a rental housing in the private market, for example. Of course, the principle of proportionality it has a stronger effect when it comes to you know, the people that are being evicted from land, from different settlements and so on. And it has in many cases it's been applied, especially for Roma people that were where they had their home, their residence in an informal settlement. But I think what we independently of these binding obligations, you know, like the principle of proportionality is maybe useful for us to raise at local level. I think that's the most important thing, you know, like if it exists at European and international level, we can, as lawyers in the local level, be able to raise it and even to include it in law, that some kind of proportionality assessment has to be done in order to balance the interests in there. I don't know if I'm explaining myself correctly.
Thank you.
But anyway, I think it's good that people understand that exists already. I think it's probably the people that are participating are not so knowledgeable about this anyway. So just to say that that Portugal ratified the optional protocol to International Covenant on Economic and Social Rights in the protocol that allows for international individual complaints for violation of the rights of the covenant in 2013. But I really don't know if it has been used by Portugal. Do you know that, Dulce?
No, I think not.
I don't have any information that of organizations that have used that or individual cases being presented. I think most of the cases come from Spain. There's one from Belgium, and I think there was one from France, but not from Portugal. So Portugal did ratify the optional protocol to International Covenant, but has not used this complaint mechanism yet. That's as far as I know. And then, for example, in terms of the Council of Europe, I know there have been different collective complaints by so against Portugal. So especially in relation to Roma rights. So I don't know if you know, but the European Roma Rights Center, they did a complaint against Portugal. That was some years ago, 2010. And the committee of social rights concluded that there was a violation of Article 16. So Article 16 is the right to the right of the family to social, legal, economic protection, which includes the right to housing. And also the committee said there was a violation of Article E. Article E is the article that has to do with discrimination. So so there's been a decision that considers that Portugal is in violation of some rights, and also Article 30, which is the right to protection against poverty and social exclusion. So apart from the right to housing, the European Social Charter, the revised Social Charter, includes Article 30, which is about the right to protection against poverty and social inclusion, and that's an interesting one. I can probably already include some a link in the chat so that you can take a look at what we have. I think the information about Portugal probably needs some updating, but I think it can be interesting for the people there. Okay, so if we don't have any more questions, why don't we start with you, Dulce? Maybe, okay, let me just show what I had on my slide. I wanted to remind you of some of the questions that I had for you, if that's okay. So before you start, so if you could tell us a bit about the legal framework on housing rights in Portugal. Okay, let me introduce you. Dulce Lopez is a professor at the University of Coimbra. For both of you, for all of you that don't know her, and she has agreed to speak to us about the opportunities and challenges to defend housing rights in Portugal. So thank you, Dulce, for being here with us. And Jan, I'm going to ask you to speak a bit about the legal framework of housing rights, and maybe give some example of housing rights advocacy, if you know some of them. And also, I would like to remind all of you that Article 65 of the Constitution says that everyone has a right to housing for him, his, her, and family. So if you could connect this to the legal framework and how the legal framework in Portugal has developed the right to housing, or has included the right to housing in a way, like for example, starting from the Lei de Bases da Habitação that was passed in 2017. And I think that I'm going to give you the floor now, because I don't have nothing else to say about this, Dulce. So I hope you can say something about it. I know that it's very difficult to do it in 30 minutes or in 20-30 minutes, but at least an introduction so that our colleagues here have a flavor.
Okay. Thank you, Maria. Thank you, FEANTSA, for the invitation. Eu vou falar em português.
I'll be speaking in Portuguese. I guess most or all the listeners are Portuguese, and Maria also understands Portuguese, and this way it will be easier to do my presentation, since I'm going to be referring to certain detailed legal issues, which are complicated.
Like it is, you have the translation in English for you, right? Okay. Portanto, vou continuar e compartilhar tela.
Well, I may go on and share with you my screen.
Eu vou só ter de desligar para poder ver aqui a minha.
Okay, I'm just organizing myself. So Let's talk about opportunities and challenges in the rights of housing rights in Portugal, and try to do the link with the homeless issue that most of you know because you work in that area more than me. So I know the legislation, and the idea here is to link these housing rights and the homeless, which are both challenges and needs, and tell you what the law foresees in terms of tools in Portugal. Very well. Just to give you an overview or a context, we won't have much time. As we all know, in the last decades, the biggest trend in Portugal, the biggest trends, is permanent housing, very often with a mortgage from private banks. That's what people do. The market, the rental market, has been forgotten a little bit, just for you to have an idea. And as there was more owners of houses, the number of tenants was reduced. So there's a group that still benefits of something, but less and less, because there were, in the meantime, revision of the laws, of the legal framework. And so the tenants still have a protection according or depending on the situation. But what we have in Portugal is a market with permanent housing, less and less people renting houses. There are several types of renting. I will, of course, be referring to them in a little while, but the social renting is residual. It's 2 to 3% only, and it's especially for those who have less income, a lot less income than the average. So according to the data, and maybe you have better data than mine, but I have the ones I have from 2020, we had a very concerning situation, probably worse than in 2019, of number of homeless people. They not even rental, not even owning a house or any other solution. These people did not have access to housing. And when I mention housing, is a very vast manner. It's to find a stable place to stay, a roof, minimum conditions of life to be able to develop itself, because that's our idea. I don't know if you know, but our constitution, national constitution, is based on the principle of human dignity. And the human dignity can only be complied with if you have minimum conditions so that there is a free development of personality. Of course, we have situations of the homeless people, and that human dignity is in danger, of course. And so this situation deserves our focus from the legislator, from all the public entities, and this is, I will tell you, is things have been getting better. These are some more data concerning the rental market. What we see is that there's no lack of housing. You can take into consideration the number of houses. In 2011, we had 45 more houses than the number of families. Well, in the data of Census 2021, these are aggregated data, there was a reduction of population and a rise of number of housing. So these are not well, these are probably a bit different to now. And in the resolution of the Council of Ministers that started a small revolution in terms of right to housing or housing right, and adopted a new strategy for housing. It focused on people without house, homeless, or so many houses without people inside. That's what they used, the sentences that were used. Not only people without houses, homeless, but another issue in Portugal, biggest problem, is the needs of finding a house for the families. According to a report from 2018, it tells us that there's a big need for relodging people because these families did not have the means, financial means, to have a house, or either the houses were not good enough, precarious in terms of construction, in terms of quality, of sanitary quality, and a certain promiscuity as well, because there's too many people in a very small space, which does not allow people to have their own intimacy. So people would have to be on top of each other. So these are, well, this is the background that we have. Now, concerning the types of housings that we have, and this is just trying, because it's incomplete, because there are many other situations and more different, and this is an approach. Its biggest or bigger insecurity, lack of access to housing, and more ownership. We have very different situations. And follow me what Maria just said, each case is a different case. So we should analyze each case in a different manner. So we have homeless people, we have people who live in informal houses made out of wood, planks. The Roma people, for example, in very often they live in this type of shanty towns or in areas or plots that are not theirs. And then there's the illegal occupation, which is the squatting. And then this squatting here in Portugal is not something that is considered to be an issue. There's a quick reaction both from the owners of the public entities. I'm not saying that we know that there is a need. Very often these squattings are just pass by. They are temporary, and they quickly end. Certain other situations of illegal occupations that exist for dozens of years, and their resolution is difficult to come about. And then we have people who borrow or lend houses, very complicated situations of farming housings and similar housings or lodgings, and people who live in deplorable situations or conditions. And then we have the kind of Airbnb, let's put it that way, the local housing. This is the Airbnb type of housing. Some are used to help to be in the housing market. Usually they are not used for permanent housing, but nowadays it does solve some problems. Then we have the student residents. We also have needs, and it seems that the market is waking up. There's a promotion of this type of lodgings for the students. And now the government has decided to bring a lot of students to these Airbnbs that are not being rented these days. Well, and then we have the black market, which is the rental market non-declared. And then we have three types of renting. We have the one where the rent is accessible, so cheap, and the legislator has found this as the way to sort all the problems of lack of access to housing. It's a type of rental in which the owners let for at least less 20% of the average of a certain district, and then they have fiscal benefits at the end of the month. So the municipalities themselves are entering this market, because the municipalities have houses as well and apartments, so they are kind of mediators. So they let to the owners and then sublet in this regime. It's an interesting solution for those who know it, but there is a problem with this. It's not for all, because these rents are at least, well, 20% less than the medium, the average. We can sort the problem for certain, but certain will not be the solution for all, especially those who are more in need. And then we have the condition renting. It's been funded. It's got a lot of limits in terms of amount of rents, etc. And then the supported renting. These are social rents that still exists. And these new policies that have been adopted is to raise up to 5% of the letting market to social rentings. But I think, based on my experience, the municipalities are more interested in the famous accessible renting than the social renting. And I think that there should be a balance here. And then there's a lot of other types of rents, the leasing of houses, and then the real right of use of and housing. There's certain novelties now that are not being regulated. The co-living, the collective property, but we are going forward, and this is the situation. Well, so there are many types of possible situations, and there is something very important in terms of housing, which is the flexibility of the housing market to be able to answer all needs. Effectively, we already have all types of rents for young people, social renting, the accessible renting, conditioned rents, and the trend now is to promote the rental market and not the ownership. So I believe that what we have to do is do better with what we already have and try to find stable solutions and have really accessible rents, because we can't just have the name on it and not be accessible. So accessible means accessible, to be able to face all the needs that show up. Well, the Lei de Bases da Habitação, which was approved or adopted in 2019, with policies. Well, there are other policies that started in 2015. A lot of decisions taken, but in truth, there was not a real identification of all the needs in terms of housing. The municipalities are the ones who know best the problems in their own territory and their residents, is to have municipal strategies for the housing. I don't know if you are aware, but with the new plan for recovery and resilience from the EU, there's lots of funds and there's a lot of fundings, and that will support these municipal strategies, identify what are the needs, who are the families, how many families there are, what's the number of members of the family, and what are the proposals in terms of reconstruction, how can the municipality help. So the idea is, with all these legislations, that housing can be available in available numbers, in good conditions, to be able to answer the needs. In the new housing policies, you see all the goals or objectives, as you see here. In number one is to create an answer for those families who live with a serious housing issue. The second objective is to guarantee housing for all those through the market. And then objective number three is to reconstruct instead of build from scratch. Reconstruct the houses that already exist. This is a more appropriate model, more sustainable to be able to answer the needs of housing. And then objective number four, which is to promote social inclusion, territorial inclusion, but also the opportunities to choose the housing, their own housings. So these are ambitious. These are aligned with the international there are certain programs. The question is to promote this issue to something else. I mentioned before the Portuguese constitution, but in truth, for long years, and we have our constitution since the revolution, just a little bit after,
housing has always been seen as a minor relative, so to speak, in terms of the fundamental rights. There are several classifications of fundamental rights, but the one that our constitution is based upon, we have fundamental rights that are freedoms, liberties, guarantees that everyone talks about, that can react against their violation. But then there are other rights, those that are economic, social, and culture, where right to housing is included. And to a certain extent, it is they were subject to as much as possible. It had to do with policies, and policies were changing all the time. They had to be weighted. So one could do as much as possible to provide for, in terms of housing, namely to those that could not have access to the so-called normal means. But things have changed lately, thanks to the basic law on housing, because now we have the social function of housing. The idea is to promote effective use for housing purpose of buildings, or parts of buildings, in order to meet the right to housing of everyone. And this means that buildings and parts of buildings belonging to public and private entities, there are different levels here, as Maria said. The fact that we are binded by the public entities to this social function, it is broader than that of the private entities, but both should try to meet the goal of ensuring decent right to housing. This means that the public entities are obliged to manage and even to buy buildings that are to be allocated to housing, but this sometimes entails some limitations to the private owners, namely as far as the rental legislation is concerned, so that they are not absolutely insensitive to the housing issues stemming from the management of a property. So it's important for them to have that perception as well. Moreover, increasingly, well, there was even a recent discussion on Zimar requesting some tourist houses to accommodate people that did not have a dignified shelter or house, and the state allowed for that, and you remember the reaction that brought about. So it's very difficult to bring about this in the private market of housing. and the right to housing, which has more teeth, so to speak, that the Constitution said everyone is entitled to an adequate housing in hygiene and comfort conditions that preserve intimacy and family privacy. Now, in Portugal, we cannot it's what it's called right to a house and right to a home. So this is more of a right to a home that is being defined here. The more precise criteria about what a dignified, decent housing should be. Now, get about the homelessness situations and what the legislation comprises on these matters. That is, additional protection is conferred to people and families in situations of vulnerability. And to begin with, we have the situation of the homeless and also minors that have been abandoned, victims of domestic violence, other victims of other situations. But the homeless situations here are treated as are included in this list as being the most relevant. Now, the funny thing is that in the law 32/2016, the law that manages the supported rental, that is the social rental, so to speak, in the procedure that where these houses are distributed, the Article 11 has certain preferential criteria to allocate those houses. Now, though the basic law admits or foresees that the homeless are at the top of a list of people in vulnerable situations, Article 11 says in any of the procedures foreseen in the previous articles, whenever the typology and conditions are delocating leasing entities, namely usually our public entities, will define their preferential criteria, namely, of course, municipalities can choose other criteria, but namely it says single parent families, people with disability or above 65 years old, or victims of domestic violence. So basically, what we have is a sorry, I have to go back to my slides. I don't know what I did. You can hear me, right? Can you see the slides? Hello, can you see this?
Yes, we can see the slide.
Sorry, because I switched screens. Now, back to my presentation. That reference did not appear in the legislation of 2016 on homeless. Now, another idea that stems from the legislation 12.4, people homeless have the right to indicate a postal address at a site of their choice, even if they don't sleep there, if they're authorized by the owner of that postal address. This is important to talk about the bank account, for instance, to collect certain type of support contacts for other types of situations, education, employment. So it is important for them to have a rule that guarantees a postal address, but this should be up to the state. We should not put the burden upon the homeless people themselves to ask someone to authorize them to use their postal address. This should be provided by the state. namely for those that have informal jobs or occupations. They say that there should be a postal address for those. Sorry, for in this kind of barracks or shanty towns, they should also have be entitled to a postal address. Article 13, number 7, the people and families in need that are in risk of eviction in the mobility, if they have the right to priority public support by the competent entities and the necessary support to have access to adequate housing. This is not very clear, but it goes in the sense that in a situation where can be talking about the transformation, the change of the state of people, of households to have housing, and if they are in a situation of homeless, then we should be, if people are at risk of becoming homeless, then they should be considered for possible emergency housing support. According to my experience, I don't work so much in the private rental, but I work a lot with municipalities, and from my experience, we have a lot of situations of illegal construction works in land that is not even allowed for building, and municipalities should monitor this, and in some of these houses are to be demolished. But then again, as I say, there we have to make a proportional judgment, and there are rights that should prevail over the obligation to resume the urban planning legality. So whenever there is a first housing, there are situations of second housing. The first housing, when there is no alternative, if there are children involved, people with special needs, then with all due social framework, it should prevail over the need to demolish the house. So we should take into consideration these situations, to follow them, see when the need ends, but I think this is obvious in my opinion. Now, I'm going to stop because I went way beyond my time. There is a possibility for occasional subsidies and grants, and also a priority is the situations of support to people that are homeless, with national, regional and local strategies, and some programs have already been implemented, some of them involving rehabilitation or even new housing in programs like Housing First. These models can be included in the local housing strategies in municipalities in situation of homeless that they are following and they want to find a solution to, and also the issue of the shared apartments. It's a way of trying also to solve the situation. Thank you very much. If you have any questions, I will be here to answer.
I was actually writing down in the chat. Please, can you write down your questions in the chat if you have any? Por favor, pode anotar as suas perguntas no chat. Chat. Mi português é portunhol.
É ótimo.
Mas eu penso que todo el mundo comprende. ¿No hay preguntas? Suas preguntas.
So there are no questions.
You can also raise your hands. If you can raise your hands, I can maybe see you. Any hands? Anything? She's been. I mean, if nobody has a question, I would like to ask a question about, especially about this postal address that you were mentioning. Like, I think probably this is one of the main problems in many countries, like not only in Portugal, like in other European countries. Sometimes the law, it's very clear. It says that every single person, regardless if they live in that place, has to have an address, a registration address in a way, because that registration allows the homeless person to access services. So it's essential. It's essential because it's the key to most rights. So if you're not registered in the municipality, you don't have postal address, then it will be really more difficult to have access to your rights. So what I have seen in other countries is that although the law provides for that, then in practical terms, sometimes there's problems, if you know what I mean. Like the law may be perfect, but there are practices that are not so good, let's say. Do you know if this is happening, Dulce, also in Portugal? Do you have any idea? And also, I see that Ricardo has a question. So after this one, I will give you the floor. Is that okay?
Yeah. Well, for what I said, I think that this specific provision is insufficient. I know that this is a big problem also in Portugal, this postal address. Of course, we could go further and say they should also at least get help to have like an email, because now everything is done through that. Indeed, there's lots of things we should assume nowadays as being linked to having a place to stay and to receive personal and professional messages, and because this is really needed when you have to, when the idea is for someone to maybe get back on the labor market, educational market. You need this is essential. And this rule, I think, goes a bit under what would be expected. This should be something that I believe mostly municipal services should provide. Okay, the fact even they have a box for it in their own services. It shouldn't be an incumbency upon the homeless person to find someone that could provide him with a postal address. So this and also from my experience, the relationship in these cases with like social security mechanisms should be better. They should be more I don't know, sensitized to this situation and to have different channels of information also in these cases. This has not been so far the case, but well, this is an indication things are improving, but not as much as we would hope for. Thank you.
Thank you, Dulce. I think there's a question from Ricardo. Ricardo, I cannot see you, but if you could put your camera on, that would be great, so that we can see your face. That would be great. If you don't have that,
yeah, but
no.
Can you hear me? Oh, okay. Now I have it.
Yeah.
Well, I still don't have it, but it's okay if you can hear me.
Yeah.
I'm sorry, I cannot do anything.
Okay. It's okay, no problem, Maria. First, primeiro, gostava de agradecer à professora
First of all, I would like to thank Dulce for her presentation. It was very useful. Sometimes it is difficult for us to have access to all this information on housing laws, and they were very clarifying. As regards the postal address, I belong to the AMI Foundation, and my colleagues, that's one of the things they do. They provide the address of the center, for instance, of our institution, so that people can have the possibility to get mail and to answer to job proposals, or even to receive their cash. But my question is there, say, a roster of lawyers, reserve, so to speak, of lawyers specialized in this area, that the institutions and people that are supported by the institutions can use, either for legal counsel or just to clarify their situation and to solve, say, conflicts with landlords, for instance, or it can be private citizens or municipalities, and to solve eventual eviction situations. So is there anything organized that can help people with that? Thank you, Ricardo. Well, we do have, like, Miguel Rosario de Castro is with us now, and he works on these matters. Hello, good morning. And sometimes he also provides some academic collaboration in these housing issues. Of course, we have lawyers that are specialized in these situations, but you're asking me if we have, like, a legal advice office with a group of lawyers? People that are not just lawyers, but like people that can advocate for the housing rights. That I do not know about. I don't think that there is. Usually these offices are linked to associations like yours or to projects in the academic world. Usually like that. And I don't know any. I know a few in immigration matters, but none, and I have worked on this specifically for housing issues, but that's a good idea. We can talk about it later. This could be a winning idea for a project, and sometimes people think about projects that are not very useful, but this would be a very useful one. So you want to speak with me? Maybe we can come up with something, an idea that will meet a need. But usually these, say, legal offices do not replace, they just provide some guidance to help people then to go to the right place. Sometimes in situations like, say, a lack of income from judiciary support, but it's also important to help the lawyer, to provide him some hints how to proceed. That could be interesting. So without getting into the world of lawyers, but just like an advice, legal advice in very broad
Thank you.
terms. Thank you.
Thank you, Dulce. Before I give the floor to Miguel Osorio de Castro, I would like to mention that, well, as far as I know, as far as I know from the work we do in Housing Rights Watch, there's no legal advice for the homeless in Portugal. I am not aware of it. So if anyone knows, I'll be delighted to know more about it. In other parts of Europe, in the last years, in the past years, there's been like the creation of street lawyers. So, for example, you probably know, but that exists in Italy, Avvocato di Strada. It exists in Hungary. Street lawyers are giving advice directly in the streets to people that are homeless or they have problems with their housing situation and so on. There are also street lawyers in Denmark, Judisten. I think I'm not I don't speak Danish, but something like that. So I think there's certainly a need for this some kind of legal advice, because always these topics are extremely difficult and very technical most of the time, and it's helpful for organization and for the homeless people themselves to have this kind of advice. And also there's also another kind of legal advice or housing rights advocates that has increased over the years along activists. So for example, in that case, I know that in Portugal, as in Spain, for example, is the La Plataforma Antidesahucios. So organizations, platforms that were organized because there were a lot of evictions at the time in Spain, especially associated to mortgage repossession, but now is more and more evictions in the rental market and so on. So these organizations, they're activists, but there's a group of lawyers that have developed knowledge about that due to that specific, let's say, problematic. And I know that in Portugal, there exists Habitat. I don't know if you are related or you know them, but Habitat, I know they are doing, but they're activists. But of course, they also try to link with the law, because obviously, in the end, an eviction is about a procedure in the law and how that can be managed in a better way, but not only from the activist perspective, but also having the law in your hands. So yeah, I mean, there's a need, and there are different initiatives all over Europe. So if you need information on things that are developing and maybe be in contact with other organizations that have had some kind of legal advice, maybe you can also contact me, contact us, so that we can put you in contact with other organizations in other countries in Europe. Okay, that was it. Okay, I see Miguel wanted to say something, so this is my turn to introduce him. Thank you, Miguel, for being here. Miguel, he's from a university in Porto, Lusófona do Porto, if I'm not mistaken. Okay, I have good memory. And he's going to be speaking about the private market and the different issues in the private market. But maybe he wanted to react on the previous question. So the floor is yours, Miguel.
Bom dia, muito obrigado.
Good morning, thank you. Maria Aldana, thank you very much for the invitation. It's a pleasure to be here. I'd like to greet Dulce. She's also one of those persons that invited me, and also to Lunda Garcia, a word of greetings. She was also part of the team and worked in the area. Now, before I start my presentation, let me complement the clarification provided by Dulce. As a matter of fact, rental and urban rehabilitation matters, public rental, for instance, and when I speak of private rental, this is another thing. Now, there are 2 or 3 institutions that may help here in Portugal. They are the following. As regards urban housing and some doubts that we have in at local authorities, so problems related to housing, how it works, there is an observatory, a watch that was created recently, and sometimes questions are asked about certain subjects on urban rehabilitation and accessible rental. It's called Observatório das Autarquias Locais, Local Authorities Watch. Now, although this is very specific for municipalities and the local authorities, it is also, they can also provide answers to questions on access to housing, how does the legislation work. This regarding the so-called leasing or rental under public administration. Then we have also a national association of tenants that can help us. This association is open to the public. You can ask them for clarification. They will clarify us about our rights and obligations, well, basically about our rights, taking into account the common citizen with few financial resources and needs advice to solve rental contracts. So we have the Observatory of the Local Authorities, the National Association of Tenants, and lastly, we also, as Dulce said a while ago, in Portugal, there is no body, there isn't any specific institution for what Ricardo asked about. So it would be an interesting project because there is a great need for this. So having that reserve of lawyers that could provide legal advice would be very welcome. Maria, can I share my screen now? Yes, you are authorized. Can you see it?
Not yet, but we can see only the folder with the files.
Se calhar abre e apresenta logo se calhar é melhor abrir e ires buscar diretamente à secretária. Exato, já está.
Okay, now there you go.
Sim.
Muito bem. Ora bem, eu vou tentar respeitar aqui os prazos de 30 minutos.
So I will try to meet the 30 minutes. I have a few notes and then I'm open to your questions. Now let me some introduction remarks about the rental market in Portugal and an overview of how we have evolved in this area and where we are today.
Ora bem, a legislação do arrendamento em Portugal tem vindo a sofrer ao longo dos tempos diversas e sucessivas alterações, sendo Portugal dos países com maior instabilidade no setor.
A lot of modifications, and there's a lot of instability in Portugal, taking into account the legislation modifications. For you to understand what we're talking to, since 1910 until 1990, the contracts were only in 1990 with a new regime for urban rental, RAU, it was possible to we had and 1 year so we could have until 1995. In 2006, establishing a special regime and with old districts or older districts, this is 2006, there was NRAU. New regime.
2006, the new urban rental regime was approved. In November, RAO, and then November, the other one. Now, the regime that the new law designed aimed at modernizing the rental market, allowing for a greater balance in the market, because the freezing of the rent led to a degradation of the buildings. The new law in 2006 tried to solve the problem of urban rehabilitation, promoting conservation works and rehabilitation of buildings, and revising the incentives to rehabilitation. and taking into account a high number of buildings that needed urgent works, and very urgent works, the obligatory works method was something the law considered.
Agilizar os despejos, com o objetivo de encurtar o prazo de despejo para 3 meses. No ano de 2012,
In 2012, there was a new step, very important for the biggest liberalization of this regime, especially when what it concerns the rental for housing. And 2006, there was a lot of constraints that were freed, and then, of course, this was better. Legislation in 2012 again wanted to give more balance in terms of contracts for housing, trying to approach those who were the owners and the tenants, or the landlords and the tenants. In Portugal, the rule is that citizens opt for buying their own housing. Well, the rental for housing represents 17 to 20% of all houses. Well, it's a very far from the ideal percentage, take into account how difficult it is to get a mortgage from a common citizen and the average income of the family, which is very low. So the Portuguese population wants to buy their own flats, their own houses, and because the rents are also expensive. So it's also important to refer that within the reconstruction during the years, there's a new strategic plan to promote and rise the number of available houses for rentals, more accessible, of course, for those who are in need. Now, these are public funds, municipalities' funds that are given to owners, to landlords, to give more dynamic to this type of market through long-term mortgages or loans, so that sorry, not mortgages, but loans to reconstruct some certain types of houses with flats, blocks of flats, for which flats can be used for long-term accessible housing. And this is to promote the access to housing. And this is the right that is within the constitution of the Portuguese constitutions, is the right to constitution. We all, as Portuguese citizens, we have the right to housing. And the legislator promotes this access and a level of effort which is compatible to the family members or the number. So in this, there's the Decree 68 from 2019, 68 from 22nd of May 2019, and this is for accessible renting. And this program is for what? For availability of housings with prices cheaper than the average price of the areas, for families which have low incomes or certain types of incomes and have a housing related to their needs, and this is what the law has stipulates. And of course, for the owners of these houses to be able to access this program, there's the tax rebates, for example, and there's a compliance of a certain types of requirements in terms of price of the rent, the minimum duration of the contracts, the insurance, income, and level of effort of the family members or the family itself. If you allow me, and before this introduction, I'd like to refer to a series of decrees that have as a goal to promote the housing market and the right to dignifying housing, and this is a right which is protected. So we have tax rebates, and we have Law 3/2019. And there's the code or IRS code with reductions. And this is 28%. And this can vary between 2 and 18% according to the contract or the rental contract. And then there was the observatory for housing. This observatory for housing and urban reconstruction was created based on law number 10 of 2019, and the objective is to accompany the evolution of the market through the elaboration of annual reports of execution. And then there's 66 from 21st of May. This is concerning compulsory works in certain blocks of flats.
Miguel, can I just stop you for a minute? Are
Yes,
we still in the introductory note, or would you like to have you passed to the other? Because we can still see your presentation and it's still in the first slide.
Porque é só esta nota. This is the
Just one more thing.
Okay.
One more thing. This is because we have short time.
Yeah. Okay. Thank you. No, is this that I wanted to know if you were progressing? Thank you. Sorry for the interruption.
Yes.
Portanto, estava eu a dizer que no que respeita à intimação.
So, as I was saying, as regards the coercive works, what was the main progress? The municipality unofficially or upon request can decide on the necessary works to be carried out to correct poor safety conditions. Then we have the aggravation of the municipal tax on buildings, a decree of 2019 that aggravates that tax in regards to buildings or parts of buildings that are not occupied in areas with greater urban pressure. This is city centers, the main city centers of cities. Then it was also created, and I think this was mentioned here, but I will send Maria a copy of this legislation. It will be easier for you to check this, but then it was created the basic law of housing. That's a law 83/2019 that defined a program framework for guidance towards the establishment of public policies on housing and access to housing, recognizing the right to housing as a constitutional priority. Then lastly, in Portugal, we recently created in law number 2/2019 of January 9, a real right to long-lasting housing. What does this mean? It's a right that grants the possibility for someone to keep his or her permanent residence in someone else's house for life through the payment of an advance and then monthly payments. Now, having said this, let's try to understand the details about how the right to rental works in Portugal, the legal regime of the rental in Portugal, and if you allow me, I will focus on urban rental. So for housing, although I could also mention for non-housing, So urban housing for urban housing for urban rental for housing purposes. Sorry. Now about the contract, the lease contract, Article 1067 and PC means civil code, because the legal regime of urban rental is all included in the Portuguese civil code. It is in the Portuguese civil code that regime of the urban rental. Now the contracts may be for housing purposes or non-housing purposes, and this is provided for in this article 1067 of the civil code. Then we have to see what is the appropriate way to celebrate a rental contract. It will have to be celebrated in writing, regardless of where it's for housing or for non-housing purposes. What elements should be included in the contract? The identification of both parties, including birth date, nationality, and civil and marital status, the location of the address of the house, of the number and date of housing license, the amount of the rental, and how it is to be updated, and the date in which the contract is being signed. Now, what happens if the rental contract was not made in writing? The law sanctions with making it null and void. It will have no effect. It's as if it did not exist. But as we know, the tenant, in most cases, is the weakest part in this negotiation, the contract negotiation. The landlord, the owner, has more economic power, and the tenant is the weakest part that has to be protected. Now, if you allow me to make a parenthesis, the trend of the modern European private law, the trend in the European private law is to protect the weakest part. And the protection of the weakest part is about those situations in several areas where one of the parties does not have the same weapons that the other party has in celebrating a contract. And that's what happens here with urban rental. So what am I trying to say? If there is no written contract and the tenant proves he has been paying his rents for 6 months and that there is a de facto rental contract because he is using the flat, the apartment, no one can evict him because one cannot invoke nullity to send the tenant away. So this is shows how the weakest part is being protected under this regime, the rental regime. Another important thing that should not be forgotten, the responsibility of the landlord. Only buildings and parts of buildings with a license of use can be used for leasing. The license of housing is a document that says that that place can be used for housing, and this license is provided for Article 1070 of the Civil Code. Again, I promised to Maria Albanas that I will send you this document. During the day, I will send you also this presentation and the document so that you can also send to your colleagues. Now, another important aspect that any citizen has to take into account, the tenant, for the landlords, sorry, should provide the energy certificate of the house. Now, what are the deadlines, the terms for the lease contract? What are these rules? So in lease contracts for housing purposes, today the minimum term is 1 year for housing purposes, 1 year, and that's the minimum, and the maximum is 30 years. So this comes in Article 1095, but there is an exception to this principle. An exception of this 1 year principle is for those contracts for non-permanent housing or for special transitional ends, say for professional motives or for education, for tourism purposes. Let me give you a few examples. Imagine that Maria Albanas decided to come to Portugal for 2 months, to live in Portugal, to monitor closely the evolution of rentals in Portugal. Now, although Maria José Albanas came here with a rental contract for housing, the legislator said for this specific case, for a professional or academic reasons, they said she came here to study or to research the market, then the law says that in these concrete cases, there is a transitional contract where the law does not require a minimum term of 1 year. It can be 2 months, 3 months, 4 months, or 1 month, and then renewable successively, as long as in the transitional rental or leasing contract, it says that, it specifies that. I can give you another example. A lady that came from Madeira Islands. She wanted to come to study to the mainland to finish her master's. She needed a house for 4 or 5 months, so she made a contract for 4 months to be able to finish her master's degree in the mainland. Another example, someone who wanted to go to Oporto for 6 or 7 months for health reasons, because that person had to undergo a treatment in a local hospital or to accompany her parents. Now, this is another example where the rental for urban housing can be less than 1 year if the motive is provided for in the contract. Then, as I was saying, I was talking about the terms. There is a fixed term and a non-defined term. How does the rental, the payment of the rentals work in Portugal? The payment of the rentals in Portugal, the rentals should be paid on the first working day following the month. So say today is the 30th of September, the rental should be paid by the 1st of October, and the legislator, again, because there can be some delays by the tenant, and again, we are always trying to protect the tenant, what the legislator says, but if the tenant does not pay on the 1st, on the 2nd, or on the 3rd of the month, he can still do it by the 8th. There is a tolerance that the payment can be made by the 8th of the following month. So, if it does not pay on the 1st or on the 2nd, we can always still pay by the 8th, and there is no sanction to the tenant. But if the rental is paid on the 9th of the next month, then the landlord has the right to require for an additional 20% of the rental in debt. It's Article 1041. And the concern of Portugal and the Portuguese legislator has been trying to protect urban housing so much that in the past, this sanction for the payment, late payment of the rental, was 50% of the value missing. And today, given the difficulties in the rental market, the high rents, and to promote this market, this sanction is now 20%. So it's a way of also protecting the weakest party, which is usually the tenant. Now, as far as the payment of the rent is concerned, in Portugal, the lack of 3 months payment gives the landlord the right to terminate the contract out of court. So it's a quick mechanism that was created. If the tenant does not pay for more than 3 months, the landlord just sending a registered letter to the tenant can terminate the contract out of court. As regards the rent, I'd like to make a comment, and Maria Albanas knows this very well, and maybe you too. In Portugal, we are still behind what is being done in, say, in Germany or in the northern European countries. You know, in the northern of European countries, the legislator has limited the amount of the rents in those critical areas with higher population density, urban centers. And why? So that there is no real estate speculation, and that the tenants are not deprived of their right to rental. In Portugal, what we have is a freedom for the parties to agree on the amount of the rent, and say in the center of Porto or of Lisbon, there is a speculation of the rent. The rentals are very high, and a common citizen cannot afford that. And why? Because the average income of a household is not sufficient to pay for these high rents. And why are the rents so high? Because there is very little offer and a very high demand. So even despite the Portuguese legislator is taking some steps in terms of urban rehabilitation, the basic law of housing, and these recent laws, but nevertheless there is a lot to be done, and we should replicate models we have in the Nordic countries and in Germany in order to set a threshold in those key areas so that people can come back to the cities, so that there should be a threshold that limits the amount of the rents to be paid. Also, the Portuguese legislation confers specific deadlines for a landlord to terminate a contract of housing rental. I'm not going to get into details. I have my in order to meet my timing. With the non-housing rental, I'll leave it out now. And so let me speak about the housing contracts. Now, in the rental contracts for housing purposes, unlike those that for non-housing purposes, the legislator again wanted to protect the weakest party, which is the tenant, and the deadlines have to be observed by the landlord. So in non-term contracts, when upon the initiative of the landlord, there is an advance notice of 5 years. So this means that the owner or the landlord, in this case of the contracts that have no-term contracts, they can only terminate a contract with at least 5 months and or 1 year before those advance 5 years in advance. If the contract for housing has a fixed term, which is the rule in most contracts, then the advance for the landlord not to terminate or not renew the contract depends on the term that is provided for in the contract. But again, Article 1097 says the following. This advance should be 240 days if the term is equal or higher than 6 years, 120 days if the term of the contract is equal or higher, equal or lower than 1 year and lower than 6 years, and 60 days if the rental contract is equal to 6 months or lower than 1 year. What are the deadlines that the tenant, the weakest party, has to observe? To tell the landlord, I do not want to stay, I'm going to work elsewhere, or I found an apartment which is more accessible. So what are the deadlines for the tenant? When the rental contract is a fixed term, the advance is 120 days if the contract is equal or longer than 6 years, 90 days if the contract is equal to 1 year and less than 6 years, and just 60 days if the contract is equal or longer than 6 months and lower than 1 year.
Thank you, Miguel. I'm sorry to interrupt you. I'm just aware that the time is passing.
How much time I have?
I can give you 5 more minutes so that you can actually finish a bit. But you know, just to focus the context that we have seen in Europe, in many countries, the private market has become the only way that vulnerable tenants could actually be housed, because there's no more social housing, or there's reduced access to social housing. And we are pretty aware of these difficulties because of the protection of the tenant is not always very well. So could you finish? I think you've already mentioned it, but maybe say it a bit more about the balance between landlord and tenant, how that is included in the balance of power between landlord and tenant is included in the Portuguese legislation. And also, I would like to know if big tenants are already working in, when I say big tenants, I am thinking on real estate investment companies that own a lot of, and how do they, if you know, if they are affecting the rent or affecting evictions or this kind of thing. If you know something about it, like, I would be glad to know about it. Do you think that's possible to say something about that in 5 minutes, something like that?
Muito bem. Eu então, Maria José.
Yes. Now, regarding my presentation, I will send it to you, my slides. What I think it's important to say in 5 minutes is that the trend in the last years in Portugal, and it has also been the trend in the European Union, is towards promoting, fostering a balance between landlords and tenants. And this can be seen in the fact that either in the basic law for housing or for urban rehabilitation regulation or for tax benefits that are provided to owners, this has caused, there's allowed for the rental market to be an alternative to buying a home. And how has this been working? Along 3 axes. First, the legal regime of urban rehabilitation, the basic law of housing through municipalities, allows for owners that do not have the money to do rehabilitation works in their buildings so that they can lease them, so they have the buildings, but they don't have the resources. Now, these owners, they can use these financial mechanisms to rehabilitate their buildings, and so that then they can be offered for rent at low-cost rents, at accessible rents, affordable rents. Now, I'm an owner. I have my buildings are rehabilitated thanks to this, free of charge. But of course, in order to make up for that, in order to compensate for that rehabilitation, I'm accepting that I practice accessible or affordable rents. Now, then we have also the municipalities, the legislation, the possibility that the buildings can be included in these programs to rehabilitate these buildings that are in need of rehabilitation in Lisbon, Porto, where the owners cannot afford the rehabilitation. Then another important leg here is the tax benefits that the owners are granted in case of private renting. What are these benefits? The landlord is entitled to a reduction in his income. He pays a tax, a lower tax than if it were a normal one. So there are tax benefits that are attractive to the landlords, the owners, that contribute to this balancing. So answering your question, at the moment, we do not have statistics that allow us to understand what is the impact of these measures, of this trade-off that is being made here. But my feeling from my work in university and in my law firm, my feeling is that there has been a progressive adjustment, and that people with that are don't have so much resources are now being able to afford their homes with more affordable rent. So I'm sure that this path is the right way to go to foster a rental, and so the unbalance between 20 and 80% will now become more balanced. The 20% and 80% between rentals and ownership. And that's it. Thank you.
Thank you. I'm really conscious that the time is it was very good for us to actually go through all those. I know in Spain we also have the Ley de Arrendamientos Urbanos, and I know that going like one by one, step by step, is really long. It will take more than an hour, maybe like an hour class in the university, I'm sure. So thank you for, you know, trying to include that in such a short time. Really, it's really difficult, I understand. So we wanted just to give like a flavor, like a bit of what's happening in Portugal, and maybe understand it a bit better. And also, yes, like for me, it was very important to understand the private market, like what is it like in Portugal, because it's becoming like a more prominent role everywhere else in Europe. So I think that you have given already the answer that it's the same thing happening in Portugal anyway. So I don't know if we have any.
Maria, desculpa, eu depois vou-lhe dar a apresentação
escrita. I will give you my presentation, and maybe I will send you an English version as well.
Okay, that would be great. ¿Alguna pregunta de los participantes?
Any questions?
No questions. I'm not sure if our 20-something people are already sleeping or they've gone for lunch.
Very boring.
No. I am sure that they're very interested, but they don't have any questions. But I don't know, like maybe to Dulce, you could also answer the question that I was trying to raise in the chat. Like for us here at European level, we see also a trend that let's say housing or real estate funds, or even sometimes not real estate funds, pension funds are investing in housing. Like housing is one of the big investment, and they are buying many apartments, and sometimes that can have an influence on the rental that people are paying, also on the eviction sometimes. Renovation can lead to evictions. And I was wondering if this is a trend that you are seeing in Portugal or not at all, or maybe say a word about how tourism also, I think you already mentioned Airbnb in your presentation, but maybe say a word or two about that, like what is the influence in the private market, and are vulnerable tenants pushed away, or the rents are getting high because of that?
Well, there is some data on Portugal that shows that at least before the COVID crisis, there was a lot of strain on housing, given or due to mostly Airbnb, tourism, this linked with rehabilitation, because rehabilitation doesn't necessarily need to be to the same function. So you can rehabilitate. The government tries to promote rehabilitate to rent for housing purposes, but for many years for the market, it was much more interesting and engaging to go to other segments like tourism, Airbnb, even the one I talked about, students, high luxury students residences, that you can also see that it's not quite housing. I think Miguel talked a little bit about it when it said that in some cases you can have contracts lower than 1 year. You have to justify. But there's a problem here because tourism is not housing, it's services, right? And so you have kind of it's not a solved conundrum here in Portugal, where tourism and Airbnb in principle is less than a month and housing is more than a year. And so you have lots of things in between that are there a bit, in the air. What do you do when you need, for instance, to locate a person or a homeless person for a certain period of time? So it's a bit undefined. What is the global framework of this? So this is one of the problems. The second, of course, is that many housing units, most of them, I should add, that were empty, not being used, are being channeled to other uses like tourism, Airbnb, or were dominantly being channeled to other uses, which means that the potential offer decreased. Also, for a number of years before this, Miguel can talk about better than I do, before the latest modification to these rules on rental, on the rental regime, it was quite easy if you wanted to rehabilitate to push the tenants off. Okay, some limitations in case of some tenants, older ones, but it was made easier, because if you wanted to do renovations, not just renovations, rehabilitation in your building, then this was an acceptable motive for termination of the contract. Nowadays, it's a bit harder. Okay, nowadays it's a bit harder. So I think we saw, in terms of timeline, we saw a time where housing was really protected. mostly the older contracts. And then we saw a moment where it was flexibilized and more liberalized. And then we are going back to a moment with this social function of property, where even in the private market, there are some more restrictions being introduced. But I think this is another question of yours, and Miguel talked about rent control. I think rent control will not come back in Portugal. This is my personal belief. We had decades of it. It turned out to be a very bad solution in the long term. Owners are very scared of it, and I think it does not fulfill the due balance that we need to find in the market. We need to have, and we do have, solutions for all in the law. We need to put them in practice, and you need to see what is really necessary. So, and this is mostly a public entity's responsibility. So I believe that the private rental market has its place. They need to be aware of it. They are restricted in some ways, but of course it needs stronger public policies as the ones as we have now. Let me just say that I'm a bit worried about where it's going, because it seems there's a lot of money for this, but I'm not sure if it will be well used, okay, as always. So that's the main problem for me at the moment. Thank you.
Thank you, Dulce. Maybe Miguel, you want to add something to that, or you want to say something else? It's always money. What I think, if Spain is something like, if Portugal is similar to Spain, when there's money, there's always a lot of people coming to get the money, but not always interested in doing the right thing about with the money. Yeah, that's something that we need. There's something else we need to control. Politicians and civil servants. So what did they do with the money? That's some kind of supervision and control to put in place. Sorry, Miguel, I interrupted. Maybe you wanted to say something. Sorry.
Não, eu só concordo com
I agree with Dulce. As a matter of fact, what Dulce said is true. We will not go back to the old rental regime, but Portugal and Europe now has more social concerns, social function, and in the rental market too, and it has been growing. We cannot forget that. For the past 6 or 7 years, we have had a socialist government. They have promoted these policies, social policies, in a more ongoing, urgent manner with a defined strategy, and that is good for this purpose. Thank you.
Thank you. Okay, I think if there's no more questions from the audience, I will ask a last question and then we can wrap up, if that's okay with you. I wanted to ask, if I understood well, the Ley de Bases, there was an important provision that says that it was impossible to evict the vulnerable individuals and families by the public administration without resettlement. Do you know this? No?
It's maybe not quite that.
It's not exactly that. Okay, maybe I didn't understand.
It says in this case, they have priority in terms of help finding. It's not guaranteeing displacement, but in help finding other alternatives. Of course, from my experience regarding decisions mostly of municipalities, it's very hard for them to evict someone, even if even if the house is totally illegal, even if they are conducting criminal activities in the house. I'm talking more about situations that are social rent, for instance. It's very difficult, because then the municipality creates itself another problem, which is homelessness, which is a far worse problem. So that's what I said, that every time I work on this, I always put into evidence the rights that are being, the rights and the interests and the values that are being put there into danger, that are being endangered. So it's very hard for this to happen when the public entities are involved. It's not impossible though. The law doesn't prohibit that, but it's quite difficult. And as you know, the problem doesn't go away. The problem just gets worse, just gets under other contours. In some cases, though, this is not only a public law issue, this is a private law issue. If you are occupying someone else's property, if you are unduly or if you are not paying the rent according to what Miguel said, if you build something, this is very common in interior areas, in someone else's land. These are things that involve private owners. And of course, there they have other means to protect what they own, right? The right to property. This is also a very complicated balance between housing and property rights. When it's public entities, okay. If people already have a house, then I don't see that it translates a lot into homelessness, thank God. When it's private entities, then the legal means are others, and they have a broader access to other possibilities to uphold their own rights. So it's not that you cannot evict someone without any relocation. You can, not usually done. In some cases, though, for instance, whenever these are some situations also, whenever it happens a lot, whenever the houses are in such poor condition, then they threat even the life and safety of the occupants. What normally happens is that even if it's private houses, the municipality tries to find, in this case, very actively tries to find different solutions. Normally they are, in some cases they are good solutions, even better ones, right? In other cases are very unsatisfactory ones. For instance, putting these people into, I don't know, pensions for months, and they cannot live a full life in a pension, right? Without a kitchen, without, so it's really a very complicated balance. There's no prohibition, but there's a lot of awareness of most municipalities that if they do evict for any of these reasons, then they will get a much bigger problem. So they tend to not to do that.
Thank you. I think we're going to leave it there. I still had a last question, but I think it's probably getting too late. Is my understanding of if European and international standards are really being used by lawyers in Portugal. Like, I know that you do, because you know about the principle of personality, and I'm not sure whether it is taught in the academia, and if it's well known by the lawyers when they do their training, if they use them in court, for example. Like, when I mean international standards, yes, I mean the principle of proportionality, the having alternative housing. Like, in general speaking, do you think that in Portugal there's room to use international European standard, or it's more just the Portuguese law, like it as it is?
Miguel, do you want to answer this?
Ora bem, essa é uma pergunta difícil de responder.
Well, it's a difficult question to answer. Myself and Dulce, in the 5th grade of our university, we had a subject which is a special contract, and we mentioned we were studying the rent contract or the letting contract, and we learn more the social character, the jurisprudence, the tribunals, and then with Bologna, that subject disappeared, and now we don't talk about that Latin contract. We don't mention it actually, and it's a pity because the Portuguese lawyers don't have this sensitivity, or they're not sensible to this, because this is a niche. It's a very specific activity sector. There are not many lawyers who know about these subjects. So I think personally that we should have a body to develop more these social policies for housing, social policies to inform everyone, especially lawyers. The lawyers, they see the urban contracts or writing contracts in the wrong manner. I'm not sure if they have this vision as I do, or if they share this, but there's a structural deficiency in this matter in the Portuguese lawyer context. I can also add the principle of proportionality is also foreseen in our constitution, and it's not very different from, or in terms of standards that there are in international terms. But one thing is theory, another one is practice. And of course, the principle of proportionality doesn't work the same way in concerning public bodies or private bodies. So it's different levels. Well, I think that it's not unknown, but it's not well implemented. And there's a deficiency in terms of market, yes, and it's not well argumented. Very often, for the lawyers of the tenants, there's that dimension. Because any case that violates the International Convention for Human Rights, and in fact, so it would be good that we understand if this reasoning and these arguments that are used are incorporated in the internal ruling. But I don't see that. For, of course, the landlords, they don't want to think about this. They want just to mention the law as it is. Those who would be interested and to be aware of and informed are the lawyers, for example, of the tenants, because they would have an interest to call or to try to change the jurisprudence in certain instances, and that is not done. It's not done because it's not aware, because a lot of tenants do not have the best support, legal support, because there's this unbalance between tenant and landlord. This is what we think. So these arguments doesn't get to the courts. So our jurisprudence is very weak in this sense. It doesn't take into account because it's not asked to take into account. So there's a lot of things to develop, raising awareness to all the participants in this matter, namely the lawyers, public services, that these international rules exist, because many of them, they know the principle of proportionality, but it's just a principle. It's there. It's not valued, and don't even know how to work with it. This is all. Thank you.
Thank you. Obrigada. Muito obrigada, Dulce, Miguel. Desde el corazón.
From